My name's James Beresford. I'm the Head of Private Client at BLM Law in Manchester. Today I'm here to talk about the importance of wills and lasting powers of attorney as part of an overarching estate plan. You may be surprised to know that 70% of the adult population of England and Wales don't have a will in place. You may be even more surprised to know that 90% of the population don't have an effective lasting power of attorney in place. The purpose of today is to explain to you why you should have a will, why you should have a lasting power of attorney, and just to give some examples of the things that can go wrong if you don't have a will. If you die without having a will, you're deemed to die intestate. And there's a couple of misapprehensions in the public where they believe certain things will happen. The first thing is that your surviving spouse, be it husband, wife or civil partner, will inherit all of your estate. That's simply not the case. Under intestacy, your spouse will not inherit everything. They're entitled to the first £250,000, your household and personal goods, and half the rest. If you have children, then your children will inherit the remaining half at age 18. This may not be what you want. To be fair, if I inherited money at 18, I doubt it would last me till I was 18 and a half, but I'd have a very good time spending it. Then, for people with larger estates, inheritance tax may be payable. Any assets that pass to a surviving spouse are free of inheritance tax, but children aren't exempt beneficiaries. So it could mean that you're paying tax when you need not be. Next, people have this misconception about the common law spouse. Unfortunately for succession rules, common law spouses or cohabitees receive nothing. I've seen it firsthand where someone's died without a will and the partner's had to bring an expensive claim against the estate. So that can cause a problem. Furthermore, if you don't have a spouse, don't have children, and then it's a lottery as to which members of your family will inherit. Worst case scenario, your estate will go to the Crown. Finally, you have no one who can control who deals with the administration of your estate. But because you've chosen not to make a will, you've made these decisions. So what can be included with an effective will? You can appoint executors. Executors are people who deal with the will according to your wishes. More importantly, if you have minor children, you appoint guardians. They're responsible for making sure your children are looked after until they attain the age of 18. After that, you decide who inherits your estate, whether they receive cash legacies or your estate outright. We can put in trust structures which will protect your assets from care home fees, or ensure that your family wealth is passed down through generations. You will see from the above that wills are extremely important. However, as part of an effective estate plan, you need to have them work in conjunction with a lasting power of attorney. A lasting power of attorney covers both your property and financial affairs and health and welfare matters. It allows you to retain control beyond your capacity. If you don't have either of these in place, then someone will have to make an application to the Court of Protection to become a deputy. Such applications can take around 6 months and can cost many thousands of pounds. However, by considering wills and powers of attorney, you can make sure that you get what you wanted. And if you don't have a will, you simply have no say. It's therefore especially important when thinking about your financial affairs to consult with a solicitor to ensure that your wishes are met by having a will and power of attorney drawn up for you.